Welcome at Chord again. Welcome to our CFWebinar, Unified Patent Court and Unitary Patent. First, we will introduce ourselves quickly. I will start, or perhaps Natalie, you may start.
Thank you very much, Gottfried. Yeah, my name is Natalie Kirchhofer. I'm a patent attorney and partner here at Coas and Florac, and heading the life science and pharma team together with my colleague Arvid here, and we are involved in a lot of contentious proceedings and have also been actively involved in the UPC preparatory phase as co-authors, but also have followed the developments quite actively. Do you want to go next?
Now you already introduced me. I'm a German and European patent attorney, just like Natalie and also Gottfried. I'm a chemist by training, and my focus is on patent litigation, nullity, and EPO opposition proceedings.
Yeah, and my name is Gottfried Schill. I'm a partner as well, and I do mostly patent litigation, especially concerning SEP, standard essential patents. Yeah, and that's it. I'm a physicist. I should mention that because you mentioned that you're a chemist. So let's start. Some further administrative information. We would like you to make use of the question and answers tool of Zoom when you have questions, and we will try to answer these questions in the course of our webinar. Yeah, and at the end of the webinar, we will also open a discussion where you will participate more in person, so that we can see you, and you will receive a corresponding link at that time or you will be invited at that time when you lift your hand, but we will clarify that later. So the first thing I would like to mention is that we are using some surveys in the course of the webinar, and we would like to ask you to make that a little bit more interactive, and we would like to ask you to answer quite spontaneously. And I immediately start with the first survey tool, survey, so I have to start it. So the first question, or the first survey is about the question: how well informed do you already feel about the UPC and the Unitary Patent? And we have these answers here: not at all, a little, moderately, good, very well, and I was already well informed in 2015, but have since forgotten most of what I have been informed. So the survey is coming in, and I believe we are already very good. And I will now end the survey and will share it with you. So you see, that is what we expected. Not at all would be a rare situation. A lot of you are little or moderately informed, good informed. Not so many very well informed. Hopefully we are. And I was already very well informed in 2015. That's the answer we expected from many as well, as we have all seen all these preparations before. So I would like to give a quick introductory statement as well before we start with our substantial issues. First of all, I would like to mention that you all know we had a long history about the introduction of the UPC. We had the constitutional complaints in Germany. We had the Brexit, and as I mentioned, we all have been quite prepared if we have been around in our community at that time, about 5 or 6 years ago. And now we have somehow the task to overcome the it has already once not entered into force feeling. So we really have the opportunity to start now again, and I believe our feeling is quite clear that there is no reasonable doubt that the UPC will come. So we really believe it will come. It will come in the next year, perhaps as early as mid of next year. Or the latest, our guess is at the beginning of 2023. Yeah, and at that point, we would like to mention, and the mentioning is perhaps not the right word. So the introduction of the UPC is really a leap step, because that's the first time that a court is competent for more than one country in the EU. We never had that before in a civil court, where you have claims, civil claims of one party against the other party, and there will be decisions rendered by a court located in any country also participating in the UPC, and will become enforceable in all other countries. So that's really something which is part of the integration of the European Union. And I believe we can be somehow proud that our area is the first one making use of, or the first time that such a court has been introduced. So, and about our presentation, you have to have in mind that we have about 10 legal acts involved in the UPC, and the 700 plus articles ruling the details of the UPC. So there's no real chance in a 90-minute webinar to explain all. So we try to make a good choice what we will explain, and for sure, you don't even have to know all of these 700 plus articles. And we try to find out which are the important ones, and especially, and that's more at the end of the webinar, after we gave an overview of all the structure, we will try to answer the question, what is relevant for whom and when? And this is also something where we believe there could be a starting point for a discussion, because of course this is our view, and you might have different views of what is relevant for whom and when. So, and now I would hand over to Natalie, and we will do that in shared role. So I will disappear and join later.
Perfect. Yeah, welcome everybody also from my side. I'll just start the presentation. Yeah, so let's get started. I have the pleasure to introduce you today to the Unitary Patent in the first part of the seminar. As you see from this agenda, we'll have a second part dealing with the UPC, and a third one concluding with the strategic considerations. And as my partner Gottfried already said, please make use of the Q&A tool during my presentation to ask any questions you might have, and we'll try to answer them along the way or between the sessions. So let's first look at the legal basis for the Unitary Patent and the UPC. And this is in fact the so-called Unitary Patent package. So it's a package of several legislative acts adopted by selected EU member states. So on the left-hand side of this Unitary Patent package, as one column, you see 2 EU regulations. So that's under the so-called enhanced cooperation. So these are not regular EU regulations like you might know from the EU trademark regulation, which are automatically in force and valid in all EU member states. That's the usual way here. For the Unitary Patent package, this instrument of the so-called enhanced cooperation, which so far has only been used once before, has been made use of. And here, a subset of EU member states can collaborate to advance legal acts and new regulations. And this is what has happened here. But what's important to remember already now is that everything we will tell you about the Unified Patent Court, the UPC, and also the Unitary Patent, it's all restricted to EU member states. And as you will see, even only a subset of EU member states. The second pillar of the Unitary Patent package is the so-called Agreement on a Unified Patent Court, so the UPCA, and that contains the statute of the court, so the UPCA itself, with articles on substantive but also more formal matters of proceedings, and then also the rules of procedure. And what's important to note here is that this UPC agreement is not EU legal treaty, but it's actually an international treaty just between the member states. And this has important implications, for example, with regard to whether or not the European Court of Justice can hear questions on the interpretation. And it cannot. So the ECJ the European Court of Justice can only address kind of questions arising from the left column of this European patent package and not on the agreement on a unified patent court. And this was actually done on purpose to actually prevent jurisdiction of the European Court of Justice for certain aspects of this new UPC system. And the unitary, so that's the unitary patent, the Unified Patent Court, UPC, for the unitary patent, which you will also hear more about today. The legal basis is in the European Patent Convention in Article 142.1, which prescribes that it's possible for several EPC member states to provide that a patent may only be granted jointly in respect of these states. And you probably already know this from the situation in Switzerland and Liechtenstein, which, for example, have also made use of this provision. In the following, we will try to update you a bit, your common general knowledge on European geography, because it's really important, in our opinion, to understand the territorial coverage of the new UPC system and the unitary patent, because what is a common misunderstanding is that the unitary patent or the UPC would correspond to the territory covered by the current European patent, and that's not the case. So here on this map, you see in blue the EPC member states, so the member states of the European Patent Convention.
So the current system, right?
The current system, the status quo. So we have 38 EPC member states, certain extension states, so that in total you can get patent coverage via European patent application in up to 44 countries. And as you know, the European patent application is handled by the European Patent Office and also granted by the European Patent Office. But it's important to note that the EPC and the European Patent Office are not EU institutions, but also international treaties outside the EU. There's a certain subset of EPC members that are also EU members. So all EU member states are also members of the EPC, but not conversely, right? So if you compare the two maps, you see that 27 of the 38 EPC members are EU member states, and important exceptions are highlighted here in blue, right? So that's, for example, the UK post-Brexit, but also Switzerland, Turkey, the EFTA states like Norway and Iceland. So the countries you see here in blue, these already now, based on this general understanding, you see that they will not be able to participate in the Unitary Patent or the Unified Patent Court because they are not EU member states.
And Natalie, everything that is in yellow here, that is EU, correct?
Right.
Yes, yeah. Everything,
right.
Okay.
That are the 27 EU member states. But it gets even a bit more complicated because also not all 27 EU member states have signed the UPC agreement or are planning to participate in the UPC. And the three exceptions we colored here in red. So that's Spain, Poland, and Croatia, for varying reasons, will not participate. Spain and Poland because they don't want to, and Croatia because they joined the EU only in 2013 after the UPC agreement was already concluded. But so what you see now in yellow here, that's kind of the maximum territory at present that's expected to apply to the new UPC and unified patent system. But at least at the start of the system, it will be even a bit more complicated because of these yellow states, while all of them have signed the UPC agreement and signaled their plans to participate in the system, not all of them have ratified, so formally ratified the UPC agreement through their parliaments. And this might still take some time in some of the countries. So these countries that have not yet ratified, that will not yet have ratified at day one, are indicated here with the white dots on yellow background. So also meaning that when the UPC and the Unitary Patent come into force, there will be an initial coverage of 17 countries, which we've indicated here. It might still grow if, like now in the next half year, further ratifications will proceed, but we expect that at day one, there will be a certain more limited country coverage. And then as time progresses, additional states, so these 7 further EU member states that have signed the UPCA will also join the system. You have in red here again the exceptions, 3 EU member states that in principle could join at some later point, but right now it's rather unlikely for political reasons. And then by way of reminder, you have these additional more than 10 EPC member states, so where European patents are also granted for, like the UK, like Turkey, like Switzerland, which will definitely not be able to participate because they are no EU member states.
So in other words, it means that you really have a progressive system, right? There could be countries that could be added later on, maybe a little similar to the community trademark, where also when a new country joins the EU, it will automatically be added there. But here a ratification is necessary, correct?
That's correct. Yeah. And also we will see it on one of the next slides. If you, for example, apply to the Unitary Patent, it's important for you to also take note which states were part of the UP system at the time the Unitary Patent was applied for, because there also you can get different territorial states. It's not like your Unitary Patent will grow later when the states exceed, but you actually need to take note of which states were part of the territory when the Unitary Patent was applied for or granted. I see here one question already in the Q&A tool, so thank you very much for this, but I will address that question anyways in one of my next slides. Okay. So this was more on the territory within Europe that will participate in the Unitary Patent and UPC system. A couple of words on the Unitary Patent, which you will now better understand, hopefully in the next couple of slides. The Unitary Patent will be on the basis of a regular EP application. So the application prosecution stage is exactly the same as for a conventional European patent application. And in the future, after grant, similar to how you now choose countries for validation, you will have the option to file a request for a Unitary Patent with the EPO post-grant. So the application phase is identical. It's an option post-grant that will exist as an alternative to the classical EP bundle patent. And also the Unitary Patent will coexist with the patents you already know, like national patents, but also, of course, with the EP country parts that are not participating in the Unitary Patent. Right, so you can get a Unitary Patent for up to 24 participating member states, but in addition, you will need to, if you want to validate the European patent after grant in kind of the remaining countries which have not participated in the Unitary Patent system, either because they are not EU member states or because they deliberately decided not to. Within the territory participating in the Unitary Patent, there will be for a given European patent application or patent post-grant an exclusive relation between the Unitary Patent or the classic country-by-country bundled patent. So you need to decide whether in the Unitary Patent territorium you choose the Unitary Patent with unitary effect over all of these countries, or whether you designate them individually.
It means it's an alternative, right? I mean, and it will stay an alternative. The Unitary Patent is an alternative to the existing bundle patent, and it will also be available in the future still, right?
Right. Yeah. And you can also increase your your flexibility in options, so this exclusivity or mutually exclusive nature is with respect to the same granted European patent. So post-grant of a certain patent, you have to decide, but of course you can pursue divisional filing strategies and choose the unitary patent for one, for the parent application, and the EP bundle for the divisional application, or pursue also national patent applications in parallel.
Are there any double patenting issues? Are you going to touch on that? Or
we will touch on that in a minute. And I hope this concept of the unitary patent and what options you will still have and will remain also in the new system will become clear from the following slides, where we try to explain the system again by way of these kind of arrow depiction, where each of the arrows represents a patent application or patent, and you have the classic situation that you file a priority application, and upon expiry of the 12-month priority period, you can file subsequent national applications, a PCT application, or directly a European patent application claiming priority. And these will then result in national patents in the end, which are under the jurisdiction of national courts for litigation. And all of this will remain the same. The focus today will be this post-grant phase for the European patent application, because that's where the changes will occur. And of course, you're aware that a granted European patent you can either get by a regular standalone European patent application, or, which is also very common, by entering the European phase via a PCT application. But what's important to keep in mind is that although the patent is called European patent, so this slide is still kind of the current situation, how it is today, the status quo. But to understand also the new system, it's really important to keep in mind that the European patent as it exists today is not a unitary patent, but actually post-grant, this European patent application falls into a bundle of national patent rights.
That's why we call it bundle patent often, right?
Yeah, or we also call it EP NAP, so for EP national part. And the country coverage here currently depends on in which countries you validate the patent, right? So you get the patent application is still central by the European Patent Office, and then post-grant, you can select which of the 38 EPC member states you will validate the patent, file translations, pay the annual fees, and so forth. So you will have your bundle of national parts validated. And again, here, like I explained in the beginning, it's important to remember that only a subset of these national bundle patent parts are EU members. And remember, right, that everything we will hear now about the unitary patent will only affect these EU members, and also only a subset. Yeah, so the blue and the green arrow, it could be the Turkish part or the Swiss part of your European patent, nothing will change. The red arrow here is supposed to symbolize a EU member state that is not participating in the unitary patent. So that could be Spain or Poland, the Spanish or Polish part. Also here, nothing will change. But for the countries here highlighted in these yellow brownish colors, these are supposed to symbolize the ones that are participating in the unitary patent package.
And
here,
all that you have shown so far is the existing system, right?
Right. So that's the existing system. All of these EP national parts are governed by national court jurisdictions. And what will change now is that you have an additional option, so an alternative option, that instead of these four, as an example, these four countries that you validated here, the 4 EU member states that you validated your European patent in, as an alternative, you can designate a unitary patent or file a request for a unitary patent. Right, as I mentioned in the introduction, it's a request that you file 1 month after the grant of the patent. So it's a bit shorter deadline than the usual 3-month validation deadline. what's already important to keep in mind now, and that's depicted here on the right, whereas before you had this national courts for all of the arrows. Now you see here that for the unitary patent, the exclusive jurisdiction for all patent litigation and invalidity action lies with the UPC. And this is also something that you cannot opt out from. So you will hear about the so-called opt-out, but remember already now that the opt-out does not apply for unitary patents, but only to classical bundle patents. So that concerns the unitary patent, but as I already mentioned, it's only an option. What will remain is the possibility to not go for the unitary patent protection, but rather to designate also these participating member countries, country by country, by the classical validation system, which gives you more flexibility, right? Because with the unitary patent, it will automatically have effect in all of these 17 plus participating member states. You cannot pick a subset of countries. It's always fixed. You may, for various reasons, decide that you want individual countries subset. So in the future, you will also be able to validate individual countries. But something important will still change here. And that's, if you look on the right, the jurisdiction for litigation, what will change after the UPC agreement comes into force, at least in the long term, all these national EP patent parts that previously were also under the jurisdiction of the national courts, in the long term, the UPC will also have exclusive jurisdiction for these. So and that's when really...
When you say jurisdiction, you mean patent infringement and validity issues, right?
Yeah. So that's kind of the plan. The long-term plan is that for all, regardless of whether it's unitary patent or an EP national part, you will have the exclusive jurisdiction of the UPC. If no opt-out is declared during a 7-year transitional period, and this brings us to this transitional period and this issue of being able to opt out, which is very important. So there is this transitional period. This is now depicted here, and on the next slide, what happens during the transitional period. The transitional period is supposed to last for 7 years, and it can be prolonged to up to 14 years. If you don't do anything and do not opt out your national parts, then there will, during the transitional period, there will be an alternative jurisdiction of the UPC and the national courts. So you as a plaintiff can initially choose whether you want to go to a national court or want to file an action with the UPC, but also, of course, a party planning to attack your patent can choose to centrally invalidate it via the UPC or file a national nullity action.
I mean, that's very important to understand, right? Because it means if you don't do anything, if you don't opt out, you will always end up in the UPC system as long as you have a UPC country, of course, right?
Well, not always. In the long term, yes, but in the transitional period, it's an alternative jurisdiction. You definitely have the risk that you may end up. For example, if a third party attacks your patent before the UPC, then you're caught in the UPC system. If you want to avoid that, you can file a so-called opt-out declaration for not only European patents, but also patent applications already in the application filed, in the application stage. This opt-out can only be filed during the 7 or perhaps prolonged 14-year transitional period. But once it's filed and registered, its effect also lasts beyond the transitional period. So an opt-out for this patent is more or less than forever. Right. There is a possibility to opt back in once, But in principle, the opt-out is also valid beyond the transitional period. And the effect of the opt-out is that you exclude jurisdiction of the UPC. So you remain kind of in the old system. Yeah, and because this fear that you might, if you don't do anything, you might be caught in the UPC system, for example, by a central invalidity attack, for this reason, yeah, it's expected that there might be a run-on the opt-out registry during the so-called UPC sunrise period. We will see that in a bit, that there will be a possibility before entry into force already to proactively file these opt-out declarations to avoid that on day one you get a nullity action and are caught in the UPC system.
Yeah, I think that's a very important message to watch out, to have this on your minds, this sunrise period and the possibility for opt-out.
Yeah.
That's something to be decided probably before the start of the new system, right?
Yeah, yeah. Yes, and that brings me to one question we have in the Q&A. So a basic question is posed here. The question is whether after the transitional period, is it correct that the only way for a patentee to avoid the UPC is to avoid EP regional phase entry and only enter the national phases of selected EP states? And that's correct. So because after the transitional period, that's shown on this slide here, in the long term, so after end of the transitional period, the UPC will have exclusive jurisdiction for these EP national parts. But remember that you can also declare an opt-out also for applications, right? Not just for patents. And indeed, the way to mitigate that is to file a parallel national patent application. And we do expect, at least in the major litigation hotspot venues like Germany, that the number of national filings will increase. And the German legislator, for example, has also taken precautionary measures regarding double patenting. So there will be no double patenting bars to parallel national German patents and identical unitary patents. So it's perfectly legal and proper to have both of these patent rights in parallel.
So to have a national German application and granted patent that is identical with a unitary patent, that is possible.
Right. Okay. So just to make sure that we're really all on the same page, because I know it's rather complicated, an alternative depiction here, which should again make it clear. So what's perfectly clear is the situation on the left and on the right. This is something that is not affected by the transitional period, and that's perfectly clear that national patents on the left, like a German national patent, that will always remain in the jurisdiction of the national court. Yeah, so the Landgericht, Oberlandesgericht, Bundesgerichtshof, or the Federal Patent Court in Munich. On the other hand, on the very right, if you choose the unitary patent, that's also clear, irrespective of transitional period or not, or opt-out or not, you will always end up with the UPC jurisdiction. So there is no opt-out for unitary patents already in the transitional phase. Where it's a bit more layered or complex is the situation for these European bundle parts of the European patent. Here, in the long term, after the transitional period, if no opt-out was declared in the transitional period, also here you have an exclusive jurisdiction of the UPC. During the 7-year transitional period, there's a temporary alternative jurisdiction of the national courts, right? So remember what I said, when you do nothing and file no opt-out, then you can enter both systems, but you also run a risk that you will be stuck in one system, because once an action is filed for that same matter, you are stuck in the national or UPC system, depending on where this first action was filed. And only for this middle situation, you have the possibility to opt out, which will exclude UPC jurisdiction, not only during the transitional period, but also afterwards.
And Natalie, so far you have talked about patents. Now, in some countries, including in Germany, there are also utility models. Can you say a few words about that? Are utility models in the UPC system? Are they outside?
Yeah.
What's the relation there?
Yeah, so there is no European utility model. So utility models are always national rights. So they are always on the left side here. So they will never end up before the UPC. Yeah, and remember, for example, in Germany, you can also branch off a utility model from a European patent application. So that is also an easy way if the 10-year term of the utility model is not a problem for your business. That's also a relatively elegant way to create a parallel national right in Germany. Okay, I think this summary here regarding the opt-in, I already spoke about. A curious thing is the third bullet point, that is still a bit unclear which, so if you file the opt-out, the opt-out provisions in the UPC agreement only regulate the jurisdiction of the court, but don't really exclude the material provisions of the UPC agreement. So it's still not clear whether the national court will then actually need to apply UPC jurisprudence and UPC agreement articles. Okay, to sum up, in the future, the choices will increase. So you will always have the option similar to the status quo on the left, where you can designate country by country. But as a new option, you will have the possibility shown here on the right that you can designate a unitary patent post-grant, which will then have unitary effect across this whole yellow territory, and possibly in the years to come, also the yellow-white dotted territory here. So in principle, you can also go through this by way of this decision tree here, where post-grant of a European patent, you will need to decide whether in the UPC member states, you want to go for European bundle patents, so validate country by country, or whether you choose the unitary patent option. And that decision you will need to make fast. So 1 month after grant, you would need to file a request for the unitary patent. Within the EP bundle patent branch, at least during the 7-year transitional period, you will need to decide whether or not to opt out from the UPC jurisdiction. And that will have the effect you see now with this coloring, that if you file the opt-out, you still have your, or maybe let's first show you what happens if you don't opt out. Then you will still have your European bundle patent, but the UPC will have jurisdiction, and the UPC, although it's a bundle patent, the UPC can issue decisions across the whole territory. So very importantly, it can also invalidate the patent across all of these yellow countries here. And if you want to avoid this, by all means, here you can file an opt-out, which will lock in the patent in the state we have right now, where for each national part, the national courts have exclusive jurisdiction. And we will talk a bit about the pros and cons of these decisions, but if you are undecided or cautious, strategies to mitigate risks here are filing, for example, parallel parent and divisional applications you cannot have identical scopes due to the double patenting bar at the EPO, but yeah, you can have slightly alternative scopes or claim categories, and then try out the unitary patent with, for example, the divisional and opt out the parent application, so that you have kind of
some test balloons, right?
Test balloons, yeah. Another thing that we also expect to increase is that national patents might be filed more, so either in the priority period or as a PCT national phase entry, in addition to the European regional phase that you will maybe enter national phases in Germany, France, Netherlands. Here a quick look at the possible pros and cons of the unitary patent, always from the perspective of the patentee here. So the clear advantage is if you want to litigate your patent, you get cross-border enforcement from a single court. You have a very large territorial extension. The proceedings are in one language for all of these states, and a very big pro is less administrative efforts and also lower costs, at least if you would usually validate more than 4 countries. So the annual fees of the unitary patent are calculated to be approximately the sum of 4 usual validation annual fees. So as soon as you would validate more than 4 countries, the unitary patent becomes attractive. And of course, if you're forward-looking and positive, it's also interesting to really test out the new system and also participate in and shape it in a way by pursuing your cases there. The cons here regarding the unitary patent, I think that the biggest risk in a way, especially for our pharma and life science clients, is this issue that you are risking a central invalidity attack, right? So similar to an EPO opposition. Previously, it was only possible after expiry of the opposition period to invalidate European patents country by country, which was a high hurdle, of course, to get full invalidation. Now, possible defendants have the possibility to file a central revocation action. There are also intricacies here regarding post-published older patent applications, so prior art under Article 54.3 for the experts among you. There's also a risk involved here that national prior art then can invalidate the entire unitary patent. Other cons are that, of course, with the new system, you don't know what you will end up with in the end, right? So you risk perhaps inexperienced judges or more exotic venues if you're sued then in Slovenia or something over your patent. Also, what you need to keep in mind is that, of course, the annual fees for patents, they increase in a stepwise fashion, and many applicants in the later years of the patent, they melt down their country coverage to save costs. This will not be possible for the unitary patent because it always has unitary effect, so you cannot shrink the country
so it's all or nothing
coverage.
Yeah, right?
All or nothing.
Yeah.
Okay, and then just the same exercise regarding the opt-out, right? So that's now not the unitary patent, but more or less the question whether or not for your classic bundle patent you want to litigate before the UPC or not. So reasons in favor of opt-out are again this that you mitigate the risk of a central invalidation. If it's important to you that you will be sure that, for example, in Germany, your litigation proceedings will be in German. That's also something you can only guarantee by opting out. If you're convinced of the known quality of national, for example, German litigation courts, because of the greater predictability and experience of the judges, that might also be a reason to opt out. So at least for very important patents, I would say among our clients that there is a tendency to opt out, because you can also opt back in if you decide to enforce your patent. But the opt-in is only possible if you haven't yet been caught in a national proceeding before. So it also has a little bit of risk.
What I find very interesting, what you mentioned, is that there are also ways of sort of having it both ways, right? Getting the best of both systems, maybe by filing a divisional application or filing a national patent application. I think that's a really interesting point that we will touch on later on again.
We just got a question here in the Q&A, because I said uniform language across the proceedings and which language will be applicable. That depends on the local or regional division of the UPC that your case will be heard at, but we will hear more about that in the second part. In the central division, for example, of the UPC, it's the language of the patent, but for the more relevant for infringement litigation, local and regional chambers of the UPC, it's usually the language of the country that the division is located in. Okay, then let's just finish up here with the contra opt out reasons. So that's contra opt out means pro UPC. Yeah, because that's effectively, if you don't opt out, that's where you end up. On the one hand, it's also the administrative efforts, because the opt out, you have to file it for each individual patent right. You need to make sure that it's the right patent owner, review your licensing agreements, whether you actually have the right to opt out and so forth, if you have multiple patent holders. So it's complex to actually get down to the actual list of patents you want to opt out, and then also to actually file the opt-out declarations. So that might be a reason. Contra opt-out is also this possibility that it might also be positive, right? That you have this possibility to litigate cross-border in the UPC system. Again, this language issue. So if you're going to litigate, it's of course also an advantage to have a central proceedings with one language, which as a plaintiff you can most of the time also choose by choosing the local or regional division that you want to file your complaint in. And I mean, that's more speciality. I think it will probably be the subject of our own webinar of ours in the future regarding opt-out and consequences. But you should be aware that, for example, in Germany, there are these double patenting provisions, meaning that if you have identical claim scopes between a European and a German patent, the German patent loses effect upon grant of the European patent. And here the German legislator has amended the Inpat UG this year to actually allow for this double patenting. But if you opt out, this double patenting kicks in again and might lead then to the loss of your national patent. So that's just something you need to keep in mind.
Yeah, yeah. I mean, when you say, or just to make sure I understand it correctly, when you say opt, or you can't really say that opt out is contra UPC, right? Because you may opt out in the initial phase, but then have the choice to opt in again, and then you have all the benefits of the new system, correct?
That's right.
Yeah.
I mean, there's a minor risk that you catch, for example, a national invalidity action, and that at least for that country will lock you in the national system. But yes, that's definitely an option to keep that option of opting back in.
Yeah.
So in the next two slides, we just summarize the pros and cons. Again, also compared them with the national patent. But in the interest of time, I will skip this now. As you know, you will receive all of the slides after the webinar, so you can check that out. What's important to note is, again, that after the transitional period, this left column here will no longer exists. So after expiry of the 7-year transitional period, no further opt-outs will be possible. And then you have automatic, for the non-opted out patents, you will have automatic exclusive jurisdiction of the EPC. So if you want to avoid that, you need to consider your filing strategies to make sure that you have parallel national patent rights in place.
Yeah.
Okay, then the last slide in the first part here on the timing. So when, this is a very important question, and the timeline here has shifted a lot in the last decade, I have to say. Yeah, but right now, the preparatory committee and also the German legislator, who has a gatekeeper function here, is very confident that actually the system will enter into force in 2022, so probably fall, winter 2022 or early 2023. Right now, the only thing that's missing is one ratification of the so-called protocol on provisional application, so the PAP protocol. 13 member states need to ratify this PAP protocol, and then the so-called provisional application phase starts, in which the UPC, so the court, becomes a legal entity and can hire personnel, recruit judges, rent rooms, and so forth. And it's expected that this missing ratification, probably it will be Austria, will still occur this year. So end of 2021, this provisional application phase takes place. And the preparatory committee expects that around 8 months will be necessary for it to install all UPC functions, get the IT systems running and so forth, and get the budget straight. Germany has a gatekeeper function here, because what's missing for the actual UPC agreement and the unitary patent to enter into effect is the deposit of the instrument of ratification by Germany. So Germany has ratified the UPC agreement, but formally this ratification needs to be deposited with the UPC to enter into effect. And here there's kind of a deal between the German legislator and this UPC preparatory committee. The current plan is that the UPC preparatory committee will signal to the German legislator when it thinks the provisional application phase is more or less coming to a close. And then Germany will deposit this instrument of ratification. And then the UPC agreement says on the first day of the 4th month after this deposit, the UPC agreement will enter into force. So that could be 3 to 4 months after this deposit. And before the actual entry into force, there will be a so-called sunrise period. There were discussions that this will likely be 3 months, where one can proactively file an opt-out declaration for European patents and patent applications already before entry into force. So kind of to avoid this risk that on day 1, you might get a central invalidation attack and are stuck in the system. So then no opt-out is possible if you already have a UPC action pending. And after entry into force, as we've explained, right, there will be this 7-year transitional period, which might be extended to 14 years. Yeah, but the UPC agreement, so the UPC itself, and also the unitary patent, they will come into effect at the same time.
And probably before, I mean, this whole transition period, the whole sunrise period, opt-out issue, that's a very important, seems to be very important issue here, will certainly be a subject of another webinar when more information is available on that.
Yeah. Okay, but with this, I think we're done with the first part on the Unified Patent Court, and my colleagues will now present the second and third part on the Unified Patent Court. So Arvid, the floor is yours.
Perfect. Yeah. Now that we have had an overview of the unitary patent and the differences to the bundle patent, let's move on to the Unified Patent Court, the UPC. The structure, jurisdiction and procedure of the UPC is governed by 2 legal frameworks. That is first the agreement on a Unified Patent Court and the rules of procedure of the Unified Patent Court. And really there are a number of versions and revisions of both legal texts. You know, it's difficult to keep the overview here. The current version of the UPC agreement is the one of January 18, 2016, and the current version of the rules of procedure is the one of March 15, 2017. That's the 18th draft of the rules of procedure. Both texts can be downloaded from the UPC website, and that is www.unified-patent-court.org. Now, going to the next slide, Gottfried, could you put up? Great. Now, let's first take a look at the structure of the Unified Patent Court. And there are 2 instances, as you can see here. The first is the court of first instance. That's the ruby colored bar here in the picture, in the middle of the picture, and the court of appeal in Luxembourg. That's the blue picture there at the top of the slide. The court of first instance consists of 3 divisions, right? The local divisions, that's the one there on the left in green. The regional divisions, that's the one in the middle in gray. and one central division. That's the one here on the right side in red color. The local and regional divisions are located in the individual member states. Now, most member states have set up one local division for this purpose. We will see this in a moment on an overview map. Now, Germany is the only country that has more than one local division. In fact, it has 4 local divisions. There will be local divisions in Düsseldorf, Mannheim, Munich, and Hamburg. The number of local divisions that a member state can have depends on the number of patent infringement cases per year. And with regard to the number of cases, Germany really is the clear champion within Europe, just counting the numbers. And so this explains why there are 4 German local divisions. There is no regional jurisdiction between the 4 German local divisions. So in case of a patent infringement in Germany, the plaintiff can freely choose between Düsseldorf, Mannheim, Munich, and Hamburg. So there will definitely be competition between the 4 German courts. And this is also much intended by the lawmakers. So you can expect that the courts will, to the extent possible, of course, cater to the needs of the plaintiffs.
And by the way, when you have experience in patent litigation, there's no surprise about the cities. So
yeah,
these are the hotspots already now in Germany: Düsseldorf, Mannheim, and Munich, and Hamburg.
Yeah.
So that's basically the reason why it has been decided to choose the same venues for the UPC court.
And there is pretty much competition between these courts already, right?
Yeah, that's absolutely right.
Yeah, there are also countries, of course, in Europe that historically don't have such high numbers of infringement cases per year. These countries can join forces and form a regional division under the UPC. Currently, the Nordic and Baltic countries have done this, and these are Sweden, Estonia, Lithuania, and Latvia. They have formed a regional division with its seat at Stockholm, and also Bulgaria and Romania are also planning a joint regional division. Now, with regard to the staffing of the courts, the local and regional chambers are staffed with 3 legally trained judges. Of these 3 judges, 2 must have the nationality of the respective country or region, and 1 judge must have another nationality. So for the German local divisions, this means there will always be 2 German judges on the court and 1 foreign judge. Additionally, the local chamber, the local division, can be extended by a technical judge. Now, in the picture here, this is the Ruby person on the left side. This technical judge can be added on request by the parties, but it can also be mandatory to add such technical judge. For example, if the local division has to decide on the nullity, on a nullity action, in addition to the infringement action, then a technical judge must be added to the bench. And we will get to this in a moment. Now, the same composition of the court also applies to the regional divisions. Here too, there is a 3+1, optional 1 composition. So much for the local and regional divisions. In addition, there is also a central division of the UPC here in red color. At the bottom right of the picture. This central division has its seat in Paris, so headquarters in Paris, and sections in each in London and in Munich. Where you end up depends on the IPC class, so the technical field of your patent Ensued. Paris is responsible for electrical engineering, Munich is responsible for mechanical engineering, and London for chemistry and life sciences. What exactly will now happen to the London section of the UPC, of the central division, now that the UK is no longer part of the UPC is not yet clear. Italy wants it and has expressed interest in moving the entire section from London to Milan. However, there's also talk of simply closing down the London section altogether and distribute then the cases between Paris and Munich. And finally, it's also possible that the London section of the Central Division will remain in London, at least for some transitional period. The court has already been set up. All technical infrastructure is there. A building room has been rented. So this is also an option. But then, of course, without English judges, somewhat awkward situation, clearly politically undesirable, but legally, this is apparently also possible. We don't know yet what will happen there, and we'll probably know more by the beginning of next year. The staffing of the Central Division is staffed is different from that of the local and regional divisions. By default, the Central Division is staffed with 2 legally trained judges and 1 technical judge. So by default, at the Central Division, you always have 1 technical judge. The chair must always be a legally trained judge, but there will always be 1 technical judge. And that's also a difference to the local and regional divisions. There are no restrictions with regard to the nationality of the judges in the Central Division. Now, how many cases will actually end up at the Central Division is not yet clear. The Central Division has exclusive jurisdiction for isolated nullity actions, that is, nullity actions without parallel pending infringement proceedings. In practice, however, such isolated nullity actions are fairly rare. In most cases, nullity action comes in a bundle with a patent infringement suit. So many people expect that the real UPC action will actually take place before the large local divisions rather than before the UPC Central Division, at least in the beginning, in the initial phase of the UPC. So this covers the first instance. Let's briefly turn to the Court of Appeals. The Court of Appeal has its seat in Luxembourg, in the building of the European Parliament, the so-called hemicycle building. The Court of Appeal is staffed with a total of 5 judges, 3 legally trained judges and 2 technical judges. It is always chaired, like in the Central Division, by a legally trained judge. And also similar to the Central Division, the appellate judges may have the nationality of any member state. So no limitation with regard to nationality. Now, in certain cases, also the European Court of Justice, the ECJ, can be called upon. That's the picture here on the left side next to the Court of Appeal. Both the Court of First Instance and the Court of Appeal can call upon the ECJ. However, the involvement of the ECJ is quite limited. Essentially, it can get involved only on questions of interpretation of the EU treaty and on the EU regulations themselves. So, for example, on the EU regulation, on the Unitary Patent, on the EU regulation, on the language regime of the Unitary Patent, and on certain other EU regulations. So, for example, the EU regulation on supplementary protection certificates. So, all in all, very limited jurisdiction of the ECJ, really no change to.
That's, I just wanted to add that that's really no difference to what we see in German civil proceedings. So there will be the possibility to go to the ECJ in such cases like SPCs, or when it comes to the fair, reasonable, and non-discriminatory interpretation under the EU regulations. That is what we know already from the existing system.
Yeah. Important to remember, the ECJ has no say with regard to validity and infringement of unitary and bundle patents.
Right.
So,
and perhaps it's also I only with respect to the technically qualified judges, we see in the process to appoint judges, which started 5 years ago, many patent attorneys applying for that position, and that is, I believe, also something which is intended. So that is what we see in some of the member states today. I believe it's Italy, Switzerland, and I don't know, I believe also Austria, who make use of patent attorneys who are appointed to the bench.
To the bench, right?
Yeah, and of course we have this difference in the bifurcation, but we'll come to that later. Yeah.
Right. Yeah.
The next slide.
Switch to the next one. Now here you can see again the locations of each court. As I said, in most countries there is one local division. Germany is the exception here with 4 local divisions. There is a regional division in Stockholm, another planned regional division for Bulgaria and Romania. The seat of the central division is Paris, with sections in Munich and London, with some question marks here. The Court of Appeal is in Luxembourg, and I hadn't mentioned that yet. There is a mediation and arbitration center in Lisbon and Ljubljana. Now, however, under the UPC, mediation and arbitration is not mandatory, so you don't have to go to arbitration or mediation first before filing a lawsuit. So this covers the structure of the new Unified Patent Court. And now, Gottfried, you continue with the competences of the court.
To which court or which local, regional division or central division, how do you come to the competence of the respective division? So there's a classic approach which we know from the German civil proceedings. That's the form of act in tort. That means where the infringing devices are sold, offered, or all the infringing possibilities. You can go to the competent to that local or regional division. So if you have sales in Germany, you can go to the German divisions. If you have sales in France, you can go to the French division. So that's nothing really new. The only difference is, and you mentioned that already, is that within a country you have no divided competence. So when you have an infringement in Germany, you can go to all 4 divisions. The next typically decision can be made on the competence is the defendant's place of residence. So if you have a defendant located in whatever country, let's take Italy, you can go, of course, to Italy. Yeah, and if the defendant has sales in Germany, you make the form of actus in tort, so you can make a choice. Yeah, that's what we know. Of course, when it comes to the central division, it's interesting when this division will become competent. That is typically, or one case is where you have both choices. You can go to the local division or to the regional division or to the central division. That's in case you have a non-European defendant. Then you can make your choice. You have both possibilities, and it's up to you what you want to choose. The next point is where you have exclusive competence is the standalone invalidity action. So which is typically a rare case, these have to be filed with the central division. And the last point here is the same. You have to go to the central division when you file for a declaratory judgment for non-infringement. Also not a very common case, but then you are bound to the central division. But you have to understand, that's important when you look at the last point, when you have earlier proceedings pending at one of these divisions, this will determine the venue and jurisdiction for all future disputes in between all these parties involved before that division, and you cannot make your choice along that table anymore. So yeah, and the next slide is about what is the subject matter jurisdiction of the Unified Patent Court first, and that's as you would expect it. The convention applies for all European patents with unitary effect, for all supplementary protection certificates. In addition, and we have mentioned that already, for all European patents or patent applications which have not yet lapsed or been granted, subject to an opt-out or not. So that's the scope of the competence of the Unified Patent Court. And the next slide shows you, and there is the this is also an example for I mentioned that we have 700 plus articles, so it's really a lot of things to rule. This is one example how complete things are ruled. Other examples are about language, very complex rules about which language can be used before court. We will come to that later, but this is here a key point in Article 32. And this is the full list of exclusive jurisdiction for the court, and there are no additional subject matters which can be treated before the UPC. And first of all, it's infringement, that's declaration of non-infringement. C is interim injunctions. We have not mentioned that. We have also urgent proceedings applicable before the UPC. We know that in Germany since decades. And then we have actions for declaration of invalidity and a counterclaim for declaration of invalidity as a reaction to a patent infringement case. That's all not very surprising. And then we have the UPC is according to F competent for damages based on the provisional protection of a published patent application. For the invention prior to for the use of an invention prior to the grant of a patent or to a right of prior use. So you have used it before the patent has been filed, and you may continue. That is with the UPC. The action of payment for license fee. If you have filed a declaration that you're willing to license a patent, somebody has to determine what is the appropriate fee. That is the competence of the UPC. And then the last point, E, is about more administrative actions of the European Patent Office related, for example, to the opt-out, where you can go to the UPC, but in a strict proceeding, which is pretty much short. Yeah. So, yeah, and the next slide is about the procedural aspects of UPC patent litigation. And as we will see, these are fairly similar to what we have practiced in Germany for a long time, while one have to say that the procedural rules allow for a lot of, let's say, possibilities. So the rules of procedure have been constructed in a way to give some flexibility to the local and regional divisions to apply or to handle proceedings in a way which they are acquainted to. But the general rules are here listed, and we know them from the German proceedings. We have the pleadings are largely in writing. We have that's new from a German perspective. You have interim procedure with the judge rapporteur, but this is typically limited to administrative issues in the proceedings. We have a final oral hearing, which should last less than a day. So a short hearing, not a week or something. We have no jury and no US style discovery. That is no surprise because the system is designed to be not too expensive, so affordable also for SMEs. The cases should take about 12 months. We have, and then we touched that issue earlier, the language of the procedure of the.
Sorry, Gottfried, on this issue of the length of 12 months, that seems very, very short.
Yeah, that's ambitious, especially having in mind that we have to handle in this time infringement as well as validity. Yeah. So it will be seen how that could be handled. Yeah, but I believe at the beginning the court might be not overloaded, so it might work, and we will see how they will handle when they get more cases. Yeah, and I'm returning to the language question. There has been a lot of discussion, but finally the language of the state is always available where the division is located. This is in Germany, German, or a designated language, for example, English, or before the central division, it's the language of the patent, which could be English, French, or German. So the burden of proof is also no surprise. The party who is claiming the advantage of the argument has to prove the fact. And with respect to costs, there is a situation where the UPC should be self-financed by court fees. We have in the infringement proceedings, we have value-dependent fees. And in the validity proceedings, there is basically a fixed fee, which has some flexible aspects for low values of litigation. Value of litigation is a number which is very used in German, but not abroad. So it's basically a price tag, what the case is valid for, or what is the value of the case for the parties. And there's a calculation, and based on that, the court fees have to be paid. And we have an aspect which also is very known to us in Germany. We have the reimbursement of the costs by the losing party.
Right.
Which
different
is
from opposition, for example.
Yeah, different from opposition, and which has always a protection against trolls in Europe.
Right.
That's an important issue here that came into the UPC as well.
Yeah, and there is one more very important question. What happens if an invalidity action is filed against the patent Ensued in an ongoing infringement suit? And in this case, the local or regional division has three options. The first option is that it can decide on the invalidity counterclaim itself. In this case, as we mentioned already earlier, it must add a technical judge to the bench. The second option is it can refer the invalidity action to the central division and then either suspend or continue the infringement proceedings. And this option 2 would be very similar to the current bifurcation practice in Germany. As you know, in Germany, the issue of infringement is decided by a different court than the issue of validity. Now, and the third option is, but this is only possible with the consent of all parties, the local division can refer both proceedings, so the infringement proceedings and the invalidity counterclaim, to the central chamber. Now, it really remains to be seen what will become the standard practice here. We expect that there will be some differences between the individual local divisions. Interestingly, surveys among the German judges who are used to the bifurcated system have shown that the vast majority would tend towards option 1. Right, so that they would prefer to decide on both infringement and validity, and only in exceptional cases refer the invalidity action to the central division. But of course, that remains to be seen. We don't know this yet. And this brings us to the end of this brief outline on the structure of the Unified Patent Court. And
perhaps I might add a few words to this question of bifurcating or not. The fact that the German judges are favoring the unification of both proceedings is when you look at the practice of the German courts, not that much of a surprise, because in fact, it's always mentioned or always discussed and criticized that the German system is bifurcated because it is, of course, technically. But when you look at the practice of infringement proceedings in Germany and the discussion of the prior art issues in the infringement proceedings, they already have a good grasp on what will be the outcome of the infringement proceedings. And so they know pretty well what they're doing, and then they will be assisted by technically educated judges in such cases. So yeah, I believe the courts are keen to do it that way, in a unified way.
Yeah, that makes sense.
Yeah.
Yeah. Do we have time for another short survey?
Yeah, I think so. Yeah, I would start that survey now, and that's survey B, and I launch it. Yeah, it should work. Would you read through the questions, Arvid, or should I?
You go ahead.
Yeah, so the first question we ask you to answer as again spontaneously, do you think that the UPC will be a success? Yeah, yes, no, or I am not sure. And the next question is very similar, but different. So anyway, is the question: do you wish that the UPC will be a success? Yes, no, or I'm not sure. So the polls are coming in. So I'm waiting for a moment. There's in the first question, there's in both questions a certain tendency. So
tendency, right?
Yeah, I will end the poll now. So and I will show you the results, and you see that there is not that so many people are uncertain about as to whether the UPC will be a success. What is fully understandable. It's a not easy situation, but at least there are more that are positive that it will be success than negative. My personal view is we have no real alternative, so we should make it a success. That's a crucial point, and and brings us to the second question: where are you mostly of that opinion? You wish it will be a success. That's my wish as well. Some of you are not of that opinion, and some of you, as I said, quite well understandable, not sure. So, okay. So now we will go to our next section of our presentation.
Final section.
Final section, next and final section, absolutely. Strategic considerations, yes. Yeah, and the point here is that I guess you might be a little bit overwhelmed by all that information given in the first and second section, and the way how to and when you do what in that situation strictly depends on who you are, for which portfolio you are responsible, of which scenarios are you thinking about. And so we want to go through the key questions with respect to that, and try to give you at the end an answer what might be relevant for a certain kind of applicant or patent owner. Yeah. So the first one is your part.
Yeah. Yeah. Let's first turn to the prosecution side of this. Really, the question: what should be my future choice in EP prosecution, right? Should I tick the box for the unitary patent, or should I tick the box for the classic European bundle patent, where I have to select individual member states? Now, if you look at this purely from a prosecution perspective, free of any litigation considerations, the single most important factor here is clearly costs, right?
Yeah.
The unitary patent generally pays off for applicants who choose large country coverage. So because, of course, there are big savings in validation costs, in translation costs, in annual fees for those who, on a regular basis validate in 20 or 25 countries. The unitary patent is clearly the first choice from a cost perspective.
And I believe I'm right that has been the key motivation for this UPC. So
absolutely, avoid translation costs, make it simple, have one unitary patent. I mean, that's the whole purpose, and this is clearly true for all patents where you have a certain number of countries.
Yeah.
Now, on the other hand, if you typically validate in only 3, 4, or 5 countries, then the situation might be different. And especially if you only validate in countries that don't have a translation requirement like France or England or Germany, you might be better off cost-wise with the classic bundle patent, right? So it's really a matter of doing the math. And as a rule of thumb, the more countries, of course, you have, the more likely it is that the unitary patent is the right thing for you cost-wise. So relatively easy and straightforward to determine. There is also no, my perspective, no real hurry in making this decision. There's still plenty of time, considering that the unitary patent will not be available as an option in the prosecution procedure until probably the end of next year.
Yeah,
right?
Right.
Yeah. Yeah. Now, the things look different if we look at it from a purely litigation side, right? There, the decision on the opt-out issue is somewhat more urgent. As mentioned by Natalie earlier on, there will be a sunrise period for opting out. The sunrise period is most likely will begin 3 months before the start of the UPC. And if you decide to opt out, it really makes sense to do this within the sunrise period, because this is the only way you can make sure that you don't end up with a nullity action at the UPC. So to avoid a nullity action at the UPC before you have the chance to opt out. So if you make this decision, really, it will be a wise thing to do this during the sunrise period. And that's why there is some urgency, not great urgency, but some urgency to this.
And the sunrise period has been expressively introduced for the companies who have large portfolios with exposed patents.
Right.
So if you have a small portfolio and no real invalidation exposure, then it's not that much of a hurry. But that is where we come to later.
Right. Yeah. Right. So now, what are the pros and cons of opting out for your existing patent portfolio? Natalie has talked about this already, but I think you can, if you look at this now purely from the litigation perspective and not from the prosecution cost perspective, the strongest argument against opting out is, of course, that in the UPC system, it's possible to obtain one single verdict, one single cease and desist order for all member countries in one single lawsuit, right? I mean, that's a great, very desirable option that has never been available. So this is, of course, the strongest argument for not opting out. And it's, of course, very convenient and cost effective, especially if you are involved in multinational proceedings. On the other hand, one disadvantage of the UPC system, probably the biggest disadvantage of the UPC system, is that you are more or less dependent on one single court, right? You put all your eggs in one basket, right? And that's probably what makes most patent owners hesitant to get involved in the UPC without any backdoor option or plan B option, right? I think you really have to think very carefully if you want to expose yourself to central invalidation proceedings. After all, you know, the validity of a patent is often not a clear-cut thing, right? We all know that the outcome can be this or that, can be one way or the other. And so here, putting all your eggs in one basket could be risky, potentially. We don't know the court yet. We don't know the decision-making process. We have learned that the time frame is quite short. I mean, you have 1 year to defend your patent. That's quite ambitious. Nothing like opposition proceedings, nothing, you know, that easily can take 2 years in the first instance. So really, that's something you have to weigh against these benefits. So from my perspective, this opt-out option does make sense, at least for important patents. and at least in the initial phase of the UPC. And especially since you have the opportunity to opt in again at a later time. So really, in my view, but that's my very personal view, opting out seems to give you the best of both worlds, and that's why I have a certain preference for an initial opt-out. I don't know, Gottfried, how you see this?
Yeah, when you look on a typical SME who has one case once in a while, and usually does not think about asserting his patents in other European countries, there's no real reason to opt out, because you can simply go ahead and when you win, you have the injunction claim for all countries of the UPC, and if not, you have it not. So, but okay, that's as I said, that's very much depend on your view,
right,
on your situation. We will come to that. We are a little bit in overtime, we see, so
we need 3 or 4 more minutes. Huh?
Yeah, it's not so long. It's, I guess, 5 minutes and plus discussion. So I can go to the next slide. Yeah, okay. The next point is we touched that issue also. Sometimes it's the question of simultaneous national protection. You are aware of the strategy which has been discussed in the context with the UPC, is to file divisional EP applications with more or less the same scope, and for one you opt out or choose do not choose unitary patent. For the other one you do not opt out or choose make a choice for the unitary patent. But there's one other option which has been introduced by the German legislator, which is that as of the point in time when the UPC will enter into force, it is allowed to have double protection by a German national patent and an EP patent, independent as to whether it is a unitary patent or a bundle patent, as long as you don't opt out for the bundle patent. So the idea is clearly here, the legislator wants to give the parties, the stakeholders, the opportunity to have a choice in between both systems, the national patent infringement system and the UPC system, and to have competition and to see how it works out. So that you have an additional alternative, which is double patenting, which is now, and this is really a change. It's in the past, a European national bundle patent. A bundle patent for Germany has killed a national German patent with the same scope. So we have here a new situation. We have to think about it, especially against the background that the German venue has somewhat unique position, and the UPC functionality is uncertain. And coming now to that point, thinking about a little bit on the timeline a little bit further, you have what is intended is that the UPC system is replacing to some extent, which extent the practice will show, the national systems like the German system. And the question is here, at some point in time for EP patents, you only have UPC competence. And then you need, if you rely on EP patents, then you have to have a UPC which is functional. So parties or patent owners should have interest to promote this situation. Right. And that is something you should keep in mind when you especially think about large portfolios. If at least is a reason to some extent support the generation of jurisdiction and practice with the UPC. Yeah, and now we come to our final slide, where we want to give that what we mentioned from the beginning, give you our understanding, and we are very much interested in hearing your views on the on situations which we know from our practice. We have these small and mid-sized portfolios where we have contentious proceedings, typically not very often, almost rare, sometimes opposition proceedings. There we believe that you basically should look at where to make your crosses, the filing strategy. Yeah, you have to adopt the filing strategy, and of course it has to be discussed how. That's based on the points, advantages, disadvantages we mentioned. The next point or the next typical scenario is mid-size and large portfolios, where you have opposition proceedings on a regular basis, but infringement proceedings are infrequent. At that point, or in that situation, we believe that you will, of course, look at your filing strategy that's applicable for everybody, but you should also look at your opt-out strategy. So that's here the situation where you should pay attention. And as we mentioned, both are time-wise a little bit more relaxed than the double patenting issue, because I missed to mention that, of course, the deadlines to file national or to validate or choose German national patents are continuously running out. So you have to think about that now. And this is here, you have to make you have to think about these issues here when you have high value patents, large portfolios, intense multi-party proceedings, and a link to that infringement proceedings, also validity proceedings.
I like your little symbols here. What is the yellow symbol again?
The yellow symbol is double protection, simultaneous protection. Yes, right. So yeah. So these are typical portfolios where Arvid is much involved in pharma, life sciences, and I am much involved in standard essential patents, where we also have large portfolios. But we have in these, there's one main distinction in between both. You are looking for, in pharma, life sciences, you're looking for permanent injunctions, whereas we in SEPs looking for injunctions to get the unwilling licensee to become a willing licensee. And we have to grant in that situations, as a SEP owner has to grant a license because of the antitrust French requirements. So that's a big difference, and this difference makes also a difference here in how you look at these double patenting issues and the opt-out strategy, and also but for both, common is you have to think about how to get this UPC working to have a venue in the future.
Right. Yeah. Absolutely. Absolutely. Yeah. I really like this idea of the having the best of both worlds by maybe filing a divisional application, keeping one in the unitary system, one in the old system. So just to maintain, to keep flexible, I think this is a very smart option.
Yeah,
that's available. Yeah, right.
Yeah. And as I said now several times, we are really interested in learning what you think about that. What are your aspects you would like to emphasize, and frankly, at the very end, it's an individual choice you have to make. Absolutely. That's for every portfolio, it will be different. Okay, so now we have. Do we have any questions and answers? I believe we have no questions and answers. Yes, and we have a final survey, which should be a quick one also. I will start it and ask you for making your choice. The first question is for what percentage of your patents do you expect opt-out? And the second question is for what percentage of your patents will you select the unitary patent in the future? That would be interesting for us if you can make your choice here. The polls are coming in. So it's like in an election in television when a new government is elected. Very interesting. Yeah. So we look at it. There is a clear tendency with respect to the first question, and there is also a pretty clear tendency with respect to the second question. I'm waiting for a few more seconds to wait for additional polls. So, okay, thank you for that. And I will end the poll survey and share the results. So you can see for what percentage of your patents do you expect to opt out? It's a clear tendency, it's up to 75%. So a lot of patents may be opted out, and even the others are considerable. 100% is no real point here, and for none, absolutely also makes sense. There are portfolios, and a lot of portfolios, where I believe opt-out is nothing you have to really think about, especially also it costs and it's administrative work and whatever. And the last question is, for what percentage of your patents will you select the unitary patent in the future? So there is that is more or less the mirror of the first question. Right. You will the choice is less on the lower side, up to 25%, and then for the higher shares, lower polls, yeah, up to 100%. It's yeah, a small percentage. Yeah, thank you very much for that. And yeah, as we said, we want to invite you also to further steps, but Arvid will take over now.
Actually, Natalie will take over.
Natalie will take over. Okay, yeah, that's.
I think this concludes the official part of the webinar. So thank you all for your attention. And then please let us know also in the aftermath if you have questions. We will stop the recording now.